today we're going to talk about what's in the best interest of the children. Hi, my name is Michelle Diglio Ben-Coran, and I'm here with Annabelle Catania, and we are attorneys over here at Legal Counsel P.A. So, Annabelle, I got to talk to you about this. So, let's say you have a divorce situation, and mom and dad have shared custody, and dad, let's say he goes a little crazy, and he's got just a crazy new person in dad's life, and the kids are complaining and don't want to go see dad, and they're crying and they're getting upset, and I'm sure this is a common scenario. What happens? What can somebody do? I mean, it's got to ache the mother to have to relinquish her children to an environment that she might potentially consider unwelcoming, and watching your kids get so upset. What could she do?
This is a really tough topic, and it comes up all the time. And I know that I had it in my own divorce. It's very, very hard. I will say that the best thing that a family can do is if there are things going on in a household that don't seem right. Number one, of course, if a child is being harmed or et cetera, you need to call the Department of Children and Families and make a report. But if it's anything less than that, you just don't know exactly what's going on, but your children are miserable, et cetera, you need to speak with an attorney. But one of the first things you should do is hire a guardian ad litem. Why? Because number one, it prevents the children from getting involved in the divorce proceedings themselves. So a guardian ad litem is hired, and they go in and they do an investigation. They will go to the homes, they will speak to the children, and they will do a report of what's in the best interest of the children. So we have a statute with all these things, these factors that the judge has to look at and consider. But without firsthand knowledge, you really aren't going to get a lot of that information in front of the judge. The problem is even if you're 17 years old here in the state of Florida, we turn 18, we're the age of majority, a judge doesn't have to listen to you, okay? A judge does not have to listen to the child, their wants and desires at any point when they're under the age of 18. You actually have to motion the court. The court has to hear the motion prior to the hearing and determines, oh yes, I'll let that person testify or I won't. Most of the time it's a no. Okay.
Really?
Yes. Most of the time it is a no. And sometimes it's really surprising, even for a 17-year-old.
Wow.
So a guardian ad litem, though, can go in. They can speak to the children. If there's a hearsay exception waiver, their reports can say the children have said X, Y, and Z, blah, blah, blah. And the court will hear that all. But even if they won't hear exactly what the children say, they can hear from an adult who's investigated and gone into those households and said, okay, something else is going on and this isn't right. And this is what's going on. This is not best for the kids. We're looking for a different type of scenario for the children to keep them safe. So,
do you get that often?
I do get it often. Actually, it's almost in every case when there's children involved, especially nowadays because of the 50-50 presumption. We are looking at ways to determine what is truly in the best interest of the children. It's really, really a difficult situation.
Wow.
Yeah.
So if you have any questions with regard to situations where you might consider it to be questionable or things of that nature, give us a call here at Legal Counsel PA. If you have questions, we have answers.